David, are you good? Yeah. Okay,
We good to go?
we're good to go. I will email you the list here in a minute.
Thank you. All right, good afternoon. My name is Tim Voss. I'm the chair of the Historic Conservation Board. I'd like to take a minute to remind everyone about the rules of this proceeding. This proceeding is at all times governed by the rules of procedure adopted by the board on September 26, 2011, amended March 23rd, 2015, and last amended March 9th, 2020. A copy of the rules of procedure is available for review online. All those planning to testify today, which does not include those solely making arguments, such as attorneys, will be asked to take an oath administered by the board's attorney when they testify. This is a quasi-judicial hearing, and as such, the board reserves the right to deliberate in private. The rules of evidence do not apply to this hearing. However, professional rules of conduct do apply, and candor of the tribunal is required. The board members are citizen volunteers and are not paid for their service. They are treated as public officials under Ohio law. Any attempt to influence them, including but not limited to bribery, intimidation, retaliation, which may include contacting their employer in an attempt to exert influence, is punishable as a crime. All should be aware that this meeting is being tape recorded. Therefore, please speak clearly into your microphone and state your name and address for the record. In the event of any technical difficulties with the video conferencing technology, I may continue or postpone this hearing at my discretion. All participants providing testimony must have both camera and audio features turned on in order to participate. With that, we'll get started. We have one item on our agenda, 1424 Central Parkway. Ms. Johnson?
So this case is a case that was tabled at the May 7th, 2021 meeting. The application for the conditional use was tabled. All discussion regarding the demolition has been removed from the report and will not be discussed today. So the applicant is seeking a conditional use for a limited or full service restaurant and drinking establishment for an outdoor area that exceeds the maximum size of 50% of the indoor area. So they are seeking an allowance for 4,722 square feet. That is a combination of the outdoor patio, which is 2,672 square feet at 1424 Central Parkway at the site that was permitted for demolition, 1,580 on the previously approved rooftop patio, and 470 at the previously approved food truck area. As stated, the demolition of 1424 Central Parkway was approved at the May 17th Historic Conservation Board. This demolition was permitted and approved, and the demolition has already been completed of that building. The applicants were advised to go and try to seek a neighborhood agreement or a good neighbor agreement with the neighborhood. They did do that. In their letter. They detailed the dates and the communication that they had gone back and forth with the neighbors or their representative. A large part of the items they were able to agree on. There were 6 specific items that they were not able to agree on, and I did outline them in the staff report. I will go over them briefly as well. The first one was the length of the conditional use term. The neighborhood wanted the term to end, the conditional use to expire on December 31st, 2022. The applicant is proposing until the end of 2023. The capacity of the outdoor area. The neighborhood wanted the outdoor and indoor area capped at 476, which is the current posted occupancy for the pitch. And that is what would be permitted for the indoor area. The applicants would like the outdoor area capped at 150 people for a total of 626. For both of these options, the outdoor area still has to meet all building code requirements for bathroom facilities. To note, the increased capacity of 150 people on the outdoor area would require 8 water closets per male and female. The current plans only have 6, which will allow for a max capacity of 480 in both the interior and all exterior areas. The number of days allowed per year. The neighbors propose the outdoor area only be permitted for 44 days a year between March 15th and October 15th. The definition of what a qualifying event. The neighbors do not want separately permitted events included. The applicants would. And on a staff note on this is that we do believe that separately permitted events, if permitted, do need to have a more definitive definition. There was no definition provided for a separately permitted event. So staff has proposed two different options for separately permitted events. One would be any permit that is issued a special events permit through the city of Cincinnati with a projected attendance of 100,000 people or more, is located within over the Rhine, West End, or downtown, and the hours of the event extend beyond the normal operating hours per the agreement. The separately permitted event shall be limited to 15 days per calendar year and shall require written approval from the Director of Buildings and Inspections or their designee. The extension will be granted in writing and finds that the permitted event is in accordance with the applicable ordinances, regulations, and rules of the city of Cincinnati, including city noise ordinances and public assembly ordinances, and the extension is in accordance with the conditions set forth in the decision. I did want to note that that second option is similar to how extra events at the casino is handled. Food truck parking on 15th Street. The neighbors would like to restrict food truck parking on 15th Street. The applicants don't feel that that they have the legal authority to restrict use on this public street. Staff does want to note that per municipal code 72344, mobile vending operating restrictions, 15th Street is not a street that food trucks are permitted on to operate. So staff does feel that this is kind of a moot point. And then security monitoring, smoking in the alley, that neighbors want the security detail to ask patrons not to smoke in the alley, and the applicants do not feel they have the legal authority to enforce smoking on the public right of way. And then as stated, there are multiple conditions that the applicants have proposed. I have outlined those all in the staff report. They are also all in the letter that they provided. There are basically only two additions that staff has noted or is recommending in addition to these 19 points. One that in regarding to number one about the outdoor capacity, adding that the establishment will have to meet building code requirements for any proposed max capacity increases. And then in regards to qualifying events and what specially permitted events, that staff does recommend that the board have a more definitive response to what that means. And so I'm not going to read every single point that is both it's in the written record in both our staff report as well as in the letter that was submitted. And so I do want to note that a second pre-hearing was not held when the applicants rescheduled. This is a standard practice of our office unless the applicant requests or the historic board requires a second pre-hearing. Only one additional letter was received today. I did pass that on to the HCD's attorney. And so with that, staff does recommend approval of the conditional use for limited or full service restaurants and drinking establishments for outdoor areas with a maximum size allowing 4,722 square feet of combined outdoor area, which exceeds 50% of the indoor area, which is 5,292 square feet. And the approval is conditioned on, there's 16 conditions. But the capacity of the outdoor drinking area will be limited to a capacity of no more than 150 people. And the establishment will have to meet building code requirements for any proposed max capacity increases. That the outdoor drinking area shall be the same square footage as the non-contributing building to be demolished and shall be confined to the footprint of the former building only. The qualifying event days are defined as FC Cincinnati official game days, TQL Stadium official event days, Bengal primetime games, Reds opening day, and separately permitted events. And they will have hours separate and apart from the normal hours as further described below. And this is where separately permitted events shall be defined, and the board can choose one of those options presented on page 4, or can propose a different definition. That the hours of the drinking area on Mondays and Tuesdays are closed on normal days, 10 p.m. on qualifying event days. The hours of drinking areas on Wednesday, Thursday, and Sundays are 10 p.m. on normal days, 11 p.m. on QE days. That the hours of the outdoor drinking area on Fridays and Saturdays is 12 a.m. on normal days, 1 a.m. on QEs. And that the ingress and egress servicing the outdoor area shall be limited to one central door entrance where entries and exit of occupants may be reasonably counted to monitor capacity limits under the agreement. That the limitation does not extend to entrances and exits that are limited to handicap purposes and to emergency only access. No speakers or amplified music may be located within or directed at the outdoor area. Applicant agrees to supply 2 electric hookups for the use of the food truck vendors as an alternative to generator sourced power. And the Pitch Cincinnati will require all food trucks to limit their electric source to the electric hookups at all times except on QE days, where they will permit food trucks to utilize generator source power up to but no later than 10 p.m. That the applicant shall not attempt to remove spaces or change hours of residential parking on West 15th. That the applicant shall secure a dedicated delivery parking space in front of the pitch on Central Parkway. That no employee, contractor, patron, or invitee of the pitch may block any portion of Wetzel Alley, the parking buffer area to Wetzel Alley, or within the dedicated bike lane. Wetzel Alley shall be fully lit along the property from dusk till dawn for safety purposes. And security shall be making regular rounds between outdoor drinking areas and the pitch indoor area at such times that the outdoor drinking area is being utilized. The gates on West 15th shall be closed at all times except when food trucks entering and exiting, emergency exit, or handicapped access is required. And that the newly constructed 6-foot fence shall be the same as the recently constructed fence on Wetzel Alley and shall continue the length of Wetzel Alley to Central Parkway.
Thank you very much. All right. Who is going to speak on behalf of the applicant?
Chairman, I'm here to speak on behalf of the applicant, Kathy Ryan, Wood Lamping.
Okay.
All right, thank you, Chairman, members of the board, for meeting with us this afternoon to continue this request. I'm going to start with the 3 witnesses that I have. I have Mr. Kier Josie from the pitch, Mr. Om Patel, representative of Moment Development, and Jeremiah Hahn, representative of Luminon. I'd like to start with Mr. Patel, please.
Go ahead.
Muted.
Mr. Patel, you're muted. Mr. Patel, could you raise your right hand? Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes. Thank you, Chairman, members of the board, and all that are in attendance. You know, our effort here was to really kind of create a successful business in the pitch. We opened at a time when it was very difficult to develop a property like this, construct a property like this, and we were able to do it in a time where we were successful in opening at the time of the TQL Stadium's opening. And there is a larger development plan that's in place, and so this request is temporary in nature. This is not a permanent solution or a permanent request that we're putting on the table here. I did, in good faith, have a lot of dialogue with the neighbors regarding this matter before it came to you on May 7th. We met in person. We also had a very lengthy Zoom call, and I had numerous email correspondence. Prior to the May 7th hearing, I was sent a list of about 20 items that the neighbors would have liked to have had in a potential good neighbor agreement. I think of the 20, I agreed to about 18, and of the 2 that were remaining, there was 2 issues going into the May 7th hearing, and that was limiting the bar's hours as a part of this good neighbor agreement, which I couldn't do just because that has little to do with this outdoor space and putting in writing, limiting the hours of the bar would be a detriment to the success of the bar. However, just so everybody is aware, the bar is naturally operating within those hours that were requested, but it's not something I could put in writing. The other issue that I could not agree to at that time was closing the rear door of the annex building as a part of the operation, putting that in writing. That's something I couldn't put in writing, but in practice, it is closed about 90% of the time. And when it is open, we don't have a ton of music in that annex room that is playing. So it's a very limited impact in terms of noise. But those were the only two issues. We went to the May 7th hearing, the demolition was approved, and the board suggested that we table the conditional use until a good neighbor agreement was met. We did our best effort in the course of the last 3 months to try to come up with a solution and agree on an agreement, but it went from 2 issues to 10 issues, back down to 6 issues. And what we were finding is that we were questioning whether there was an intent to actually have an agreement, because our request initially was just for a 2-year time frame, and this has gotten so delayed in legal back and forth that we've actually lost the year of 2021 in terms of a season to have this outdoor use. So that is why we increased our request from 2022 to 2023, so we could capture an additional season. And so that is our concern, is that we're trying to come up with a good amicable solution, and it just doesn't feel like there's a reciprocation in an intent to actually have an agreement in place. I feel as an operator, and I think my partner Kayor will allude to this in a moment, we've been great neighbors, and we've done a great job of operating in consort with making sure that the needs of the community are met. But we just don't feel like there's an intent to actually have a solution that's in place. And that's why we've come back with trying to come up with a solution that does meet the needs without having a good neighbor agreement, but proceeding so we can execute this this temporary use. I will say that the opposition is one of those cases where there's no compromise. It's either it's everything is agreed to or nothing at all, is kind of the feeling that we've gotten. This is the same group that I think also opposed TQL Stadium even coming into the community. TQL has been a big surge in terms of its success, its revitalization of the Central Parkway corridor, the West End area, and OTR, especially coming out of COVID. It's been a great success. This is the same group that's opposed the parklets that, quite frankly, saved many bars and businesses in the OTR district during COVID. Same group that's opposed the Liberty and Elm project. There's a trend that any type of development that's put to the table is opposed by the same group. So our stance is we've made a really solid effort to try to come up with a solution to meet the needs, and hopefully we can move forward by continuing to do that. And we thank you for your consideration, because we feel like we've put forth a quite reasonable request on the table. As far as which item or which avenue that we would like to proceed with when it comes to the qualifying events, we are good with either route. We would prefer the 15-day route, just because it's already being utilized by a different establishment in the market. We feel like it would be great to just follow suit, but I would leave that up to the board in terms of what their preference would be. With that, if there's any questions, I'd be happy to answer, but thank you for your time.
Ms. Ryan, who's next?
Okay, next, excuse me, I have Mr. K. Josie.
Point of clarification, can I cross-examine the witnesses that Ms. Ryan's calling?
You may. Let's take a step back. We'll give the attorneys a chance to cross-examine as we go. So Mr. Suter, if you want to go ahead and question Mr. Patel, go ahead.
Thank you. I just have a couple of questions, Mr. Patel. One, you said on your direct examination that the pitch is currently naturally operating during the hours of operation. Can you expound upon that and clarify what you meant by that?
I think the pitch currently during the weekdays closes by 10 p.m. and on the weekends closes by midnight, which I believe are within the residential hours that were requested by the opposing party by the neighbors during this negotiation prior to the May 7th hearing.
Thank you. When
we can put that in writing.
Can you tell us when the pitch opens?
The pitch opens.
So I can speak to that.
I'm asking Mr. Patel first because I think we have to go in order, right, Mr. Boss?
Yes, please.
The pitch opens. It's event driven. So there are times where the pitch opens in the morning, but there are outside of an Olympic game or a game that's in a different time zone. There is a standard hour that the pitch will open, and I believe my operating partner would know that it's that specific time that's the natural time that it would open.
All right, we'll come back to that. Mr. Suter, what else do you have for Mr. Patel?
When you say the pitch opens in the morning, are you aware that the pitch on occasion opens at 3 o'clock in the morning?
We have opened at 3 in the morning for a very limited group of people wanting to watch an Olympic sport.
So how often during the year will you be opening in the middle of the morning, 3 in the morning?
Object to this line of questioning. He's getting into why or when the interior of the pitch bar establishment is open, which has nothing to do with the outdoor operating hours.
I agree. Move on, Mr. Suter.
Will the point of clarification, will the operating hours then have a minimum opening time for the outdoor?
Mr. Suter, we're discussing the outdoor space, not the indoor space right now. Can you limit your question to that?
Yes. So will the outdoor space be open at any time during the morning, Mr.
You're still asking me?
Yes, I'm just asking you, will the outdoor space?
The outdoor area will be open for that outdoor time that we had specified in the staff report. It will not be a consort with.
I'm sorry. This is the court reporter. The
Yeah.
audio, I could not hear
Mr.
most of that
Patel,
answer.
can you repeat your answer, please? Mr. Patel, repeat your answer, please.
No, we can't hear you, Mr. Patel.
Patel, can you either correct what's going on or hang up and call back in? Because we're not getting you right now.
You hear me now?
Can
Yes.
hear you?
Yes.
Yes, go. Mr. Suter asked you the hours that you'll be open outside. Are there, Mr. Suter, I'm paraphrasing, are there examples when the outdoor area would be open for special events in the morning?
No.
All right, Mr. Suter?
Okay. Thank you very much. That's all I.
I'm sorry, was there an answer to that question? I did not hear one. It was
The answer is
inaudible.
no.
No.
Mr. Ryan?
Next
would you
item, Mr.
like to
Chair.
have any follow-up questions with Mr. Patel, or have your next witness, please?
Next witness, please.
Mr. Josie, if you could take yourself off mute, raise your right hand. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Floor is yours.
Just wanted to introduce myself. 11-year OTR resident. I've been living on 12th and Walnut for the last 11 years. Ohm and myself and Caduce have been operating another bar in Over the Rhine for the last 3.5 years, Cobblestone OTR. And I just wanted to kind of speak to our customer clientele and our business. So over the last 3 years, and as far as the Cobblestone pitch, both of our established combined between Google, Facebook, Yelp, we have a 5-star rating. And we do use a third-party security company to manage the crowd on game days when the FC Cincinnati is playing. Also wanted to speak to the attorney Suter's question about, when we open up early. Yeah, we have opened up early. We have opened up at 3 a.m. before, when the U.S. women's national team was playing in Japan, and a group of high school girls were here wanting to watch. It was not a sales event. It was just me and my business partner opening up for these high school girls that were looking forward to watching the U.S. National women's team play throughout the Olympics. And I think that's okay. I think that's a positive thing. We're a community building location. So we did that probably 4 or 5 times until they lost. And afterwards, we got a great feedback from the girls. They wrote us a card speaking to how grateful they were, and it's mutual. I think we believe operating these establishments is beyond just for profit. It's building up the community. And so that's an example of, we opened at 3 a.m. because in Japan, that's when the games were being played live. And that's when the ladies at Princeton High School and their girls wanted to watch. I think it's a positive. And I would hope that the neighbors think that would be a positive too. Moving on to other things I wanted to highlight about our operations. We do a weekly cleanup around our bar. That's not technically our land. It's the alley, but we do it. That's part of being a good neighbor. In the beginning, I remember several neighbors of ours reached out to us about finding. The claim was that our customers left a mess in the alley. So I went down in the alley and I saw multiple glass bottles of Smirnoff. We don't sell glass bottles. We don't sell Smirnoff glass bottles. So that's not even us. We clean it up because that's what we do. But that's the kind of things that we're saying. We're always looking to be a good neighbor. We're not seeing that from them. We're also 21 and under all days except game days. Like starting at 7:30 and after is the only time we're 21 and up. So we're very family friendly. We have, we welcome on Saturday mornings when we open. We have kids in strollers here. And just to kind of speak to our clientele, we've got P&G events, Ernst & Young, Accenture, GE, wedding rehearsals, workouts with Orange Theory, the high school women's soccer team, U14 national champs. Like our customer base is quite family friendly. So we're not throwing parties here, right? We're building up the community. We're being available for the community for what they need. And to Ohm's point, we close at 10 p.m. on weekdays. And a lot of times we close at 10 p.m. on weekends too. And then I will say just to speak to the approach that we're taking, during construction and even while we open, multiple times my staff has felt uncomfortable because our neighbors have just we're not open for business, and they'll just essentially trespass onto our location. So they'll either wait inside of our property line for someone to open the door, or they'll just come inside. And so, but we know where they're coming from, and we're fine with that. But we just want to speak to how we actually operate. And the letter that I think Tender Mercies wrote to us, they're our neighbor over at Cobblestone, speaks kind of to how we actually operate our establishments. We do a lot of things that go unsaid. We give back. We don't talk about it, but we just do it. But in this case, I had to ask Russell to speak to our character. And so that's why he submitted that letter, which I think you guys should read. But I just wanted to add all those things on top to what Ohm said. So, and then just, before us, there was someone else. And I would tell the neighbors that live next to us, before you guys, there was someone else. Like, this is not a neighborhood that you can necessarily own. We're just living here for a while, and we're operating a business here for a while, but in the future, it might be somebody else. So let's not get so attached to that this is ours. It's ours for now, and we should take care of it. We should be good neighbors to each other, which we feel that we are. But we hope that you guys see it that way. It's there was someone before us. We're here right now, and there'll be people after us. So I'll leave it at that.
All right. Ms. Ryan, anything else you'd like to have on direct?
No, Chairman, I do not.
Mr. Suter, would you like to cross-examine?
No, I think I'm okay. Thank you, Mr. Chairman.
All right. Ms. Ryan, you have Jeremiah Hahn, is that correct?
Yes.
Mr. Hahn, would you raise your right hand?
All right. Mr. Hahn, do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead.
All right. I just wanted to speak to condition number 2 regarding the capacity and the water closet addition that supposed is being required to be upgraded. The condition being dictated by the building official, the intent is for the additional occupancy to meet the building official's assigned amount. So I just want to be clear on that 2 permanent fixtures may not be the solution, but it would be whatever the agreed upon amount is by the building official.
All right.
That is all.
Mr. Suter, cross-examine?
No, thank you, Mr. Chairman.
All right. Ms. Ryan, those were the people you said you had. What else would you like to tell us?
I'd like to have a closing argument after all witnesses have gone, but I have nothing more this time.
All right. We do have one other person I see that signed up, Kevin Schubert.
I'm just here in support of Lumina.
Okay. All right, Mr. Suter, you want to proceed now?
Yes, thank you, Mr. Chairman. First, one housekeeping matter. We did submit a letter on August 17th, 2021 at 12:27 p.m. And I did not hear that mentioned by Ms. Johnson in the list of letters that were submitted. Want to make sure that that letter is in the record as well.
Chairman, I have not received that letter from either Mr. Suter or from staff. I have not had an opportunity to review it.
I do not have a letter that I received. Sean, did you send it to me?
I send it to Ms. Maines.
Okay, I did not receive that letter. It could have been sent to the board, but it was not received by to my office or to my attention.
Can we?
I see it. I see it in my mailbox. I can forward to the board and to Ms. Ryan.
The letter was forwarded to all the board members on Friday. I did not send it to Beth or Kathy, it was just to the board.
Yeah, I received it Friday at 3:51 p.m. and read it shortly thereafter.
Does that letter get uploaded to Project Docs? That's how I figured that Kathy would have gotten a copy.
I received no notification through Project Docs.
We do not use
Historic
Project Docs
conservation
for historic
doesn't use
conservation
Project
board.
Docs.
Oh, you don't use Project Docs? Okay, that's my bad. Okay. Well, the letter is in response to the letter Kathy Ryan sent, her previous letter. So that's for.
I would object to the submission of the letter, not having received it. I was aware that Mr. Studer was an attorney of record on this case and have forwarded everything to him that I forwarded it to the board. I should have received that letter. Would have had an opportunity to review it and to prepare my witnesses, any sort of testimony and response where necessary. So therefore I would object.
If it works better, we can just kind of address it on the record here and not worry about the letter.
Let's do that.
Okay. So there are a number of things I want to address. Obviously, we had made a good faith attempt to come up with a good neighbor agreement. We had sent drafts back and forth. Not sure why the petitioner decided or the applicant decided that we weren't acting towards getting an agreement, because we were. So it just sort of ended, and then they requested this hearing. So here we are. We did put effort into it back and forth. It's not an all or nothing. Obviously, we got to 6 items that are remaining. One of them is a big item. All along, we were told that it was going to be a 1 year through 2022. Now it's going to be through 2023. And I think it's really important also that in the middle of our discussions, we saw an advertisement saying that the bar was going to open up at 3 a.m. Now we know after today that that's never going to happen outside. That's on the record. And we expect that to be the case. But, opening hours are just as important, evidently, as closing hours. So that's something that we hope the board will consider as part of this. But really the law, if you're just focused on the law, it only really addresses 2 things, and 2 things only. And this is about the Over the Rhine Historic District. That's why you all are involved. And this is about historic conservation, but it's also about surrounding land uses. And we have an update on the surrounding land uses. As you may be aware, we mentioned at the last hearing, just make sure that refresh your recollection, that most of the land uses on at least the east side of this property are residential. So as we're listening to all the great things that this bar is doing and how much fun it is to have this bar across from an MLS stadium, which is probably very good for the owners, I'm sure, we have to keep in mind that this is also in a residential neighborhood, and the surrounding land uses are residential. So the question has to keep coming up: do you want an outdoor beer garden in your residential neighborhood? And at least the clients that are here in opposition do not necessarily, without a number of conditions. But I think we have to step back first before we get into the conditions and talk about really what's at play here in the law. And that is, one, and the standard is as follows. The standard is for conditional use, it must be necessary and appropriate in the interest of historic conservation, so as not to affect the district's historic architecture or aesthetic integrity. So is it necessary and appropriate, which is a high standard? The applicant bears that burden. And I don't know how they show that an outdoor beer garden is necessary for the interest of historic conservation. We don't think that they've complied with that requirement, that required showing. The second one has to do with whether this is compatible with surrounding land uses. The staff report talks about surrounding zoning, but it doesn't necessarily address consideration of how surrounding land is currently being used. The current zoning is a CCA, that's a commercial community auto-oriented zoning. It's the kind of zoning that you would find on Beachmont Avenue or Coleraine Avenue or Glenway Avenue. I know Beachmont's not in the city, but Glenway or Coleraine Avenue. It's just zoned inappropriately for the location. This historic, walkable historic district is zoned for car uses. So it's strange. So my clients have made a petition to the city of Cincinnati, which was filed on August 16th, 2021, which is appropriate to take into consideration in this matter for a rezoning from that CCA commercial community auto-oriented district to an RM 0.7 residential multifamily district. Now
Excuse me, Chairman, I know this isn't testimony, but that is absolutely inappropriate to take into consideration at this time, and I would object to any discussion of a pending rezoning in that regard.
Mr. Ryan, I appreciate your comment, but I'm going to allow Mr. Suter to have his time, and you can respond after.
Mr. Chairman, that one of the factors is absolutely that can be taken into account in this situation is any rezoning, proposed rezonings or rezoning applications that's specifically in the code. And so therefore, it is fair game to talk about. It is a matter of public record. It's been filed. It has not been heard yet. And so we don't know if it's going to be rezoned. That is true. But we're trying to get the zoning in a place that reflects the actual land use. And I think that's important because if you look at the standards for conditional use within a historic district, like I said, it has to be necessary and appropriate for the historic conservation of the district, but it also has to be something that's consistent with any proposed amendment to the zoning code. It has to be consistent with and protect adjacent uses or properties from light, noise, and visual impacts. And it's impossible to say that with these types of hours of operation, with the activity that's taking place within the beer garden, drinking primarily, that this isn't going to have an effect on adjacent property owners. That's disingenuous. We know it's going to. Question is, can we mitigate those impacts? I think we've worked in good faith to try to do that. Disappointed that those negotiations and discussions ended. The stadium has a good neighbor agreement. Most of these types of outdoor uses and over the Rhine have good neighbor agreements, and we believe we should have one here. At this point, we have a rezoning application pending that's not been ruled on. We got stopped sort of halfway through for no apparent reason on the negotiation of the good neighbor agreement. Frankly, we think the best approach is to table this proposal again until the City Planning Commission has an opportunity to review the rezoning application and figure out if this is compliant with the surrounding zoning as it may be amended, but also for us to get this good neighbor agreement in place. We have these 6 issues, let's hammer them out, and then maybe we can resolve this. Otherwise, we're going to have to oppose it, and I think the law absolutely is in our favor in this regard. So with that, I'm going to turn it over to anyone else from the residents, nearby residents that want to speak, and I will stand down at the moment. Thank you.
Thank you. The first person we have signed up, Margie Waller.
Ms. Waller, if you could take yourself
Yes.
off mute, raise your right hand. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Floor is yours.
Thank you. One thing that I wanted to clarify, because I've been confused about this, is the use of what's called the food truck area. The food truck area is in addition to and separate from the expanded outdoor space, and it has been used this summer as outdoor space. It's called the food truck area, but to be honest, I haven't seen a food truck there in quite a while. And so I'm just wondering, I mean, we see anywhere from 70 to 100 people in that area. And it is, I mean, I can look at it from where I'm sitting right now. The noise carries straight over to my house. It carries next door to where children live and are trying to sleep. how does that fit into this? I guess, I mean, it's a question. I have some other comments to make, but that's one thing that I'm left wondering about, and wonder if the zoning folks or CB staff can clarify how that fits together with the 150 people they want to add to the 476 already allowed.
You want to go ahead with your comments?
Okay, so no one can answer that question?
I don't believe there's anything in the procedures that allows for someone who's giving public comment to ask questions directly of the applicants. So if they want to respond to rebuttal, they can, but they're not obligated to.
So to be clear, what that tells me is they're actually having another 250 people in the space. And I think that would probably change the requirements for the building code, for the number of water closets that are necessary. It creates extreme noise already, just with the people they have been having in the food truck area. The noise carries right over here, and they say they're not having parties, but they are having parties. People are loud, they're drinking, and the noise does carry, and it really is inappropriate in this residential area. I think, as we said at the last hearing, Patricia and I, who you'll hear from in a minute, did literally walk around the neighborhood and categorize each of the buildings. And it is with the exception of the health center, which is a block north, it is a residential neighborhood. This is where people live, people sleep at night. It has changed, granted, over the last 10 years, but that's what the bar owners have moved into. I am deeply concerned about these definitions, and in addition to the one that's been noted already, I want to point out that if the owners are allowed to have later hours, outdoor hours, anytime there is a stadium event, that is literally almost every day. And that's why the opponents have said, we'd like to limit it to the number of event days, which means like full stadium event days, allowed under the planned development, which the zoning approved for the stadium, plus the other days that were originally indicated by the bar owners. I feel like this is a place where what we were originally told has really gone off the rails, because now they have these very open-ended definitions for when they can keep the outdoor area open late. And then we also were originally told that this was only for 1 year. Given the way that they have been using the outdoor space they already have, I don't really feel like we've prohibited them in any way by, asking to negotiate this good neighbor agreement. And as Mr. Suter pointed out, our last response to their proposal for a good neighbor agreement, we never heard back. Nothing. Zero. All we got was notification that this was going to be moved forward into reconsideration. So we never heard back what they thought about any of our issues. So just to summarize, it really isn't, now that we've been experiencing it, it really isn't compatible with the way that the neighborhood is used. We would oppose another, on top of the 100 or so that are already out there, another 150 being in the space, and ask that the board deny this conditional use unless there are really clear rules about the number of nights, and that they would not exceed the 44 that we have recommended. Thank you.
Ms. Bryan, would you like to cross-examine Ms. Waller?
I have nothing, thank you.
All right. I also have Selena Yon signed up.
Hi, my name is Selena Yoon. I live on 15th Street.
Ms. Yoon,
Right hand,
could you raise your hand? Thank you. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Floor is yours.
go ahead.
Okay. So I'm a neighbor, but I have not been participating in any of the good neighbor agreement. Therefore, I actually do not have a full information to I don't know enough I do encourage development in OTR because it's one of the reasons I have moved to OTR is the mixed neighborhood vibrancy. And while we are residential, I also have my office here. When I clicked on the approved use, when it's RM 0.7, it said no office use is permitted. Whereas when it's the way it is now, it is permitted. So I don't know them at all about zoning. I don't want to all of a sudden be in a place where my use is no longer permitted the way, it's not an open whatever. So I realized that this is more about the outdoor bar, but when I heard like zoning change, I'm going like, what's going on? Because I don't know anything. So I just do want to put on the record that without knowing too much about zoning change, I have a concern about that. And I do share Marge's concern about too much noise due to outdoor. So I agree. And it was new news to me to learn that it was open at 3 in the morning. Granted, it was inside and not outdoor. So I hope to learn a little bit more of the issue and that I can see both sides, but that's more of the, I guess, official position I have that the food truck is a big concern of mine because I don't know what that means because I'm on the 15th Street.
Okay. All right. Ms. Ryan, would you like to cross-examine?
No, thank you, Chairman.
All right. Cassandra, do we have anybody else that's checked in? That's already I had checked in on my list.
I believe Patricia Bittner, it was the second email that I sent you an update on.
Oh, sorry. Let me, before we get carried away. Got it. Okay. Ms. Bittner?
Yes.
Can you please, thank you. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Floor is yours.
Thank you. Yes, I just wanted to, I think Mr. Patel mischaracterized our group. We're a pretty diverse group. We're just people who live, close to the pitch and have real concerns about our quality of life. I personally voted for the stadium and I love the parklets. So, and I think the woman who just spoke before me is, I don't know, we don't know each other that well, but I think we all have different perspectives, but we share similar concerns. The manager of the pitch talked about the pitch being a family-friendly place, but I don't understand why it's a family, he calls it a family-friendly place, and Mr. Patel said that the current hours of operation are naturally sort of matching the hours we asked for. I think the biggest sticking point in our good neighborhood agreement was the hours of operation. And we simply asked for the typical hours of operation that the city has in a case where there's a bar abutting a residential neighborhood. So we're not asking for anything that's unreasonable or super restrictive. We're asking what a normal family-friendly good neighborhood business would do next to a residential neighborhood. And I've personally talked with a lot of the families in the neighborhood who have young children, and they have big concerns. I mean, they're going into the 3rd year of their pandemic, and now we have a noisy bar thrown into the neighborhood that's operating until 2 a.m.
I'd like to object to any hearsay evidence about concerns of individuals who are not present at the hearing.
Okay.
Thanks, Brian.
Okay, and I just want to say, also originally the pitch owners, I personally have not been on that property. So again, I think Mr. Patel mischaracterized our group when he talked about me. I've signed on the letter that Sean, Sean Suter represents me. I've never been on that property. I've never really, anyway, I just wanted to clarify that as well. That's not me. I don't know who that is. And then also the pitch described the outdoor area originally to us as a place where they could social distance. And I was in favor of that. And I'm sympathetic to the owners of the pitch during this pandemic. I mean, I want to be a good neighbor as well and accommodate them so that they can provide a safe space for their customers. But this has evolved into something else. They want to add another 150 customers to a business that's already beyond what the fire marshal has said is a safe occupancy for their building. And I don't know how they control those 150 additional people.
They're not before the board.
Pardon?
I would object to any testimony regarding fire code issues as they are not before the board.
Okay, I think it has to do with their current occupancy and adding an additional occupancy.
So Ms. Bittner, we need the chair to respond to the
Oh,
objection
sorry.
from Ms.
Ms.
Ryan.
Bittner, Ms. Ryan is correct. We are not here about fire code or maximum occupancy per se. If that's in violation, that's a building order, not something that we're dealing with. So please limit your comments on things that are actually before the board.
Okay, I think that my concern is that how is the pitch going to manage that additional 150 people when they've not demonstrated they're able to control the people in the beer garden and the food truck area. So thank you. That's all I have.
Ms. Ryan, would you like to cross-examine Ms. Bittner?
No, thank you, Chairman.
All right. Cassandra, is there anybody else that I haven't gotten an email on?
No, not that I'm aware of.
All right. I'd like to clear one issue up, and that is as to rezoning. We are faced with the zoning as it is, not as people would like it to be. And I think so we're somewhat limited on that score to the existing zoning. I think that we're, to the degree that people would like to see the zone change, that's a question that goes beyond this board's purview. And the caveat to that I think might give some consolation is, should the zoning change, this is a temporary request, and whether it's 2022 or 2023, should the zoning change, then it would be looked at differently at that point. But right now, the zoning is what the zoning is. With that having been said, I'd like to invite Ms. Ryan to have a closing statement, and then I'll follow up with Mr. Suter.
One quick point of order, Mr. Voss, is I believe that the applicants are entitled, if they would like, to put on rebuttal testimony in response to anything that they have heard.
Ms. Ryan,
Opposition or from the public.
do you have rebuttal that you would like to present?
Mr. Chairman, I do not have any rebuttal testimony, though I would ask that as the applicant, we would have the final argument.
Fair enough. Mr. Suter, would you like to have a closing statement?
I would. Am I going first then?
Yes, please.
Okay. Thank you, Mr. Chairman, members of the board and staff. As set forth in section 1445.13 of the Cincinnati zoning code, there are elements of consideration for a request for conditional use, which are intended to ensure that the request is seen in light of its possible adverse impact on the surrounding area. Those include hours of operation, determining whether operating hours are compatible with adjacent land uses. I think we've shown some rebuttal to the applicant's assurances that they are from the actual adjacent land users and land owners, that these hours of operating, especially those in the middle of the morning, are not compatible. Neighborhood compatibility, the proposed work is compatible with the predominant or prevailing land use, building, and structure patterns of the neighborhood surrounding the proposed development. It will not have a material net cumulative adverse impact on the neighborhood. We've certainly worked hard to try to come to an agreement to mitigate any cumulative adverse impacts. We were unable to come to that agreement, unbeknownst to why for us, but the proposed work is not compatible with the prevailing land use, whether it's zoned for residential or not. The prevailing land use is indeed residential. And this outdoor beer garden with 100, 150 people drinking and reveling is certainly not a compatible land use with residential uses directly adjacent. One of the other factors, and this is 1445-13I, are proposed zoning amendments. And this has to do with the proposed work is consistent with any proposed amendment to the zoning code or the land development code, then under consideration by the City Planning Commission or Council. So with all due respect to the chair, that is a factor that can be determined by the board and considered by the board. And there is a rezoning request currently pending before City Planning Commission. I do understand that, you know, you have to kind of live with what's there now, but there is a request pending. And we've asked you to look at the actual land uses and not necessarily the technical zoning classification of the neighborhood. And then adverse effects, any adverse effect on the access to the property by fire, police, or other public services, access to light and air from adjoining properties, traffic conditions or development, usefulness, or value of neighboring land and buildings. We believe that this outdoor beer garden with this kind of intensity will have an adverse effect, certainly on the adjoining properties. We're concerned about the food trucks. We're concerned about property values of the neighboring land and buildings from this intense commercial use. In this case, each of the factors weigh against granting the conditional use. With respect to elements, hours of operation, and neighborhood compatibility, the pitch's use of the food truck area, which is noisy and long hours, as the functional extension of its bar, is at direct odds with the residential character of the surrounding neighborhood. This use has adversely impacted the nearby residents already in their quiet enjoyment of their property, easily satisfying element J, which is adverse effects. Finally, it would be especially inappropriate under element I, which is the pending rezoning to grant the conditional use while that zone change request is pending. For all these reasons, we appreciate your time. For all your reasons, we respectfully request that the conditional use be denied. Thank you.
Thank you, Mr. Suter. Ms. Ryan?
Chairman, members of the board, I would start again by saying this is a commercially zoned area in which the residents in that area are themselves conditional uses. The only reason this is before the board today is because of its adjacency to a residential district within 500 feet. Those that are coming before you now are individuals who have chosen to live in an area that is commercially zoned with conditional use requirements of residential. And those were that way, I would presume, within the last several years. When this negotiation process started, it began in May with the understanding that there were a number of terms that the neighborhood would like the applicant to consider. The applicant engaged myself, an attorney, to help assist with that negotiation, a negotiation which we have laid out before you in the letter. While I don't think it's a matter before the board to evaluate how well each side played or how well you think which give and take was more fair, at the end of the day, the applicant has made it very clear that they're looking to support their business for a couple of seasons of the soccer season. And as you can see in the letter provided, we did have 39 days of negotiation and 5 back and forths about that. As you will see in the letter, I've detailed it a little bit more. This is certainly nothing at which we just dropped off the face of the earth and began to ignore them. After 17 days at the last go around and a number of terms which that grew or were backtracked and changed, it made it clear to us that we were on the same page with an overwhelming number of the conditions. And a couple related to capacity or number of days were things that we were simply at an impasse. Those things, if you run through that table, you'll see there's kind of a back and forth. And in the interest of moving things along, there's a certain point at which you have to make the judgment call to move on. And more importantly, this is within the context of zoning approval. And you've got to really strike a special balance between serving as the zoning body that evaluates the standards against the conditional use requests and a body that is policing what would be a negotiation between the neighbors and the applicant. I think you'll see that the applicant went well above and beyond with trying their best to meet a number of the terms that were provided. As you saw, we came forward with 16 conditions and with what we believe to be fairly reasonable requests with respect to capacity, number of days, and the like. As far as the number of seasons are concerned, again, we've used this season to try in good faith to negotiate an agreement with the few members of the neighborhood that have taken opposition to this request. And with respect to those terms remaining, as Mr. Patel has stated, we would request, as staff has recommended, to have one of the two recommended special event days added in addition to the game days we've listed, with the second option being preferred. With respect to a capacity, again, I think I would suggest that the 150 or even taking that off as a condition altogether, understanding that that is very largely dictated by health, building, fire code issues and is not something that is necessarily appropriately addressed under zoning. You've heard some testimony and some back and forth regarding the operations within the bar itself, which I would remind the board is not part of this conditional use request. With respect to the standards, I think before I go into those one by one, I would disagree with Mr. Suter. Yes, there is a standard about pending zoning amendments. There are two reasons why that is absolutely inappropriate here. The first is, even if it were an appropriate consideration, it would only be an appropriate consideration if it was on the table as a pending a zoning amendment when this outdoor drinking area was applied for. This is something under the vested rights doctrine that cannot be considered as an issue after that has been applied for. And this only recently came up. And more importantly, that provision in the code is a provision that is not trumped in any way by the vested rights doctrine in Ohio. And what the vested rights doctrine says is that when an applicant perfects an application for something and then the zoning changes thereafter, they have secured the right to the zoning as it stands the day they applied. And the way that this applies to the pending zoning amendment issue, I would argue there's one way that it's relevant and one way that it's illegal. The way that it is relevant is to the extent that an applicant applies for relief and there's a pending zoning amendment that is in that applicant property owner's favor, I would argue that that factor is something that a board should consider. But because there is a vested rights doctrine that says even where there is an amendment that the council adopted that's not yet effective, it cannot be honored or recognized if that application is filed. So to the extent that there are issues pending that are against an applicant, if the actual rezoning cannot apply, the consideration of a pending one certainly cannot either. So just to be very clear, we do not in any way think that anything that may never even get to a committee at this point has any bearing on this application. You've heard from the applicant that this is something that will help the pitch. It's part of the the operation of this establishment. It allows additional people, particularly during the COVID period. Very clear, 2 seasons we believe is reasonable. And again, that's all they've ever asked for. And we added on 1 season when the negotiations we attempted this time took place. This season has now largely gone on without the benefit of that outdoor area. Excuse me. There has been no evidence put forth before the board of any sort of, police calls or any, this date I had this issue. There is no significant compelling evidence put forth by those in opposition with any sort of level of specificity whatsoever to say, here are the specific issues, here was the time of day we had the issue, here is the type of issue we had, and because of that, the conditions that this applicant is asking for are unreasonable. We've heard some very broad generalizations, again, between the last hearing and when we resubmitted, it's been a couple of months at least, where they had the opportunity to provide you that specificity, and we just have not seen that. With respect to the type of use that is here, it is a commercially zoned area. Whether, as Mr. Suter said, it's automotive or not is not really the point here. It's a commercially zoned area, and the use that this outdoor area would support is exactly the type of use that was contemplated for and zoned for in this area. And we would also urge the board to consider, this is an administrative hearing, and part of that is to discard any sort of speculative comments made by parties that don't have any sort of concrete testimony that they've provided in that regard. This proposed use also is within, there's right-of-way buffering from each block next to this area. It doesn't butt right up against a residence. And there is a certain level of distance there, even where they are a conditional use. And so we do believe this is very much a compatible use in the neighborhood. You've got a stadium on one side. You've got residences mixed with commercial, zoned for commercial on the east side. And here we're simply asking where there is an approved operating, drinking, eating establishment, that's something with 16 conditions, including limited hours, a number of different things to temper any sort of impact on the neighborhood, is right there as a transitional use in an area for which it is zoned. We believe that we have met the proposed standards, and we fully agree with the staff's recommendation as proposed, and as I said, with Mr. Patel's preference for the second option as far as the special event stays. But we would respectfully request the board approve as staff's recommendation shows. Thank you.
Thank you. All right. At this point, I'd like to offer the board members an opportunity to ask questions. Does anybody on the board have questions for either the staff, the applicant, or those in opposition?
Mr. Chair, I would like to ask, could we get the owners to talk a little bit about the operation of the food trucks? Is that special events every night? What's the thinking there?
Ms. Ryan, who would be the appropriate person to address that question?
I'll defer to Mr. Patel, but he may be able to tell you differently.
I think Mr. Joshi would be the best person to.
Patel, hold on. We're having a real problem with your audio.
I can speak to that. So far we've had, I think, about 9 food trucks, and they've been here for home games when FC Cincinnati plays and for private corporate events.
And you guys call them. That's part of your That's
Yeah.
not just them showing up because it's a
Right.
public event. It's okay.
And we require them to have an adapter to plug into our 50 amp outlet so that there's no noise. On the first game that we had, there was a food truck that pulled up on the sidewalk that, we can't really tell them to leave. They just pulled up. And at the time, we didn't have our fence yet because it was on back order. But since we've gotten our fence, obviously, there's no food trucks that pull up on the sidewalk anymore.
Okay. Thank you.
Yeah.
Other questions from the board?
This food truck thing seems to be a sticking point. My question is, or questions, you don't own those food trucks, but you do make a profit off of those food trucks. And also, what is your experience on game days when you've had a food truck? How many people congregate there, and how late does the food truck stay?
No, we don't charge them. It's not something we profit off of. They're typically there from 4 p.m. to 9 p.m.
Mr. Chair, I did have one more question. The closing hours, generally speaking, at 10 p.m. As I recall, that's was imposed by the state during this COVID period that we're going through. And so all references are to that, but I think that is how, and I could be incorrect, but as late as bars are allowed to serve alcohol. So I guess my question is, assuming we get back to normalcy at some point, I assume you guys would go with the flow and take advantage of whatever hours are allowed. If we get back to midnight or 1 o'clock or something like that, or
That might be true of the bar, but we're being asked to set hours for the outdoor space within the conditions,
right.
irrespective of where the state ends up. Other questions?
I have a question for Mr. Suter. This has been going on for quite some time. I'm curious why you delayed looking at filing for rezoning until a week ago.
Thank you for that question. Well, maybe Margie, you can answer that, or someone from the group better than me. Margie, do you have an answer to that?
Yes, as we mentioned at the first hearing, we were working with a city council member, Steelbach. There are several ways you can request a zoning change, and one of the fastest ways is to work through a city council member. My understanding is there was some confusion about the process, and the planning commission was working through the law department, and it just didn't move forward. And so even though it may still move forward, the residents working with Mr. Suter decided that we would go a different route, which is a petition route. And that is where you have to get a majority of the residents of the area, the property owners of the area, to sign the petition and file it, which is what we did a week ago, with the vast majority of the residents signing the petition. And we've already met with the planning commission to discuss how that will move forward. So you're right, that petition process started a week ago, but the original request was many months ago.
Other questions or comments from the board?
No, I'd like, Mr. Chairman, I don't have any more questions, but when everybody's ready, I'd like to move that we move to an executive session, just briefly.
I'll second that.
I just
All right.
I had a clarifying point.
So I'm hearing something, but not very clearly.
The only point I wanted to make was that our hours are not COVID hours.
our hours are not COVID hours. There are established hours.
Thank you.
All right, we've had a motion to go into executive session. And a second. Mr. Zelasco,
Aye.
Mr. Weiss, Ms. McKenzie,
Aye.
Ms. Smith Dobbins,
Yes.
Mr. Sunderland.